Well, thanks, folks. I appreciate you having me here today. I want to take a little bit of time and talk about, there's an awful lot I could talk about, but the most recent and in-your-face affront to our Constitution and our Bill of Rights is in the NDAA of 2012, the National Defense Authorization Act of 2012, which contains a provision in Section 1021 which clearly authorizes military detention, military trial, and also extraordinary rendition of anyone that the president wants to accuse of being part of the enemy in the war on terrorism. And it's plain as day, and yet we have congressmen who voted for it. You know, it was overwhelmingly passed in the House and in the Senate, in large part because it's in the military bill, the authorization bill for the military. No one wants to vote against that. But even after you point out that, look, you're authorizing this not only for foreigners, not only for the enemy in Iraq or Afghanistan, but it's authorizing it for U.S. citizens, and they'll say, no, it's not doing that. So I want to talk to you just for a second about how wrong they are and how absolutely positive I am and others that it does just that. And what this really is just, this didn't come out of the blue. What this really is the latest codification of a claimed authority and power that's already been going on now since 2001, since right after the 9/11 attacks. Almost immediately after 9/11, Congress passed what is known as the Authorization for Use of Military Force of 2001, where they authorized the president to use whatever military force he thought was proper against any nation, group, or individual that he determines had anything to do with 9/11. And it gave broad discretion, broad authority to the president, at the time President Bush, to use his war powers to go get the bad guys. Well, under that authorization for use of military force and pursuant to it, we had the Iraq and Afghanistan war and everything else that was done. It's a critical moment in history when Congress gave that authorization. But you might say, well, they only gave authorization for use of military force. It didn't say anything in there about detaining American citizens or anything else like that. But it's been interpreted and construed as authorizing the detention of not just people in Iraq or Afghanistan who were suspected of being part of the insurgency, but also American citizens. And it's been used to detain 2 U.S. citizens so far. One was Jose Padilla, and the other one was Yasser Hamdi. Both of them American citizens who were accused of being part of al-Qaeda or aiding al-Qaeda. And both of them were taken to military brigs in the United States and held for approximately 3 years each without an indictment, without a grand jury indictment, no jury trial, none of the normal procedures you would get if you're accused of a crime. And the claim by the Bush administration was, and this has been consistent ever since 9/11, is that the powers of the commander-in-chief are not limited to foreigners or to people of a nation that we're at war with, but can be used here at home as well. And so the spying of the NSA on Americans without warrant was excused and defended as being, hey, that's not normal criminal law. The Fourth Amendment doesn't apply. That's the commander-in-chief surveilling the battlefield, and America is a battlefield also. That was the argument. So for surveillance, that argument was made. And for detention of these 2 U.S. citizens, the same argument. It doesn't matter if they're citizens or not. What matters is they are accused of violating the laws of war. That's the argument. This was challenged, and in the Fourth Circuit, in the Padilla case, the Fourth Circuit, let me back up a second. So this was challenged by lawyers from the ACLU and other organizations, both Padilla's detention and Hamdi's detention as well. But in their challenges, they really didn't focus on the Constitution itself. They didn't focus on what really was going on. Instead, they focused on separations of powers. They said, well, Congress hasn't authorized military detention. And that was the only thing they really talked about. And I'll talk about what they should have said in a minute here. So what the court did, though, in 2004 in the Hamdi case is is the court listened to these arguments. And the Bush administration argued that, well, we don't need authorization from Congress because the president has an independent power as commander-in-chief, a plenary power, unlimited power as commander-in-chief to carry out the war. And they argue, this has been a consistent argument, it's called the unitary executive idea. And it was not just in the Bush administration, but also the Obama administration made the same arguments, that once there's a war, the president can do what he thinks he needs to do to win that war. And in fact, they would also argue that the president gets to determine when we're at war. He gets to determine whether we need to go to war. Once the war is on, he gets to determine who the enemy is and what has to be done to win the war. That's the claim. So going into this Hamdi case in front of the Supreme Court, the Bush administration argued that we don't need congressional authorization. The president has this independent power to do this, and Congress has no right to interfere at all. Well, the court listened to that, and the other side was saying, no, Congress, have to get congressional authorization first, and Congress has not given that. That was the ACLU's answer. So what did the court say? Well, the court said, we don't have to reach the decision, we don't have to decide whether or not the president has an independent power to do this, because we find that Congress did authorize detention of U.S. citizens when it authorized the use of military force in 2001. So once the court decided that, ACLU shot out of the water. What do they got left? Nothing, because it didn't really even argue the Constitution itself. So, but why is it that the court didn't say, not only can the president not do this, but the Congress can't even authorize this? That's the constitutional answer. The reason why they didn't do that is because they are slaves to precedent. And the court in 2004 in the Hamdi case is relying on a 1942 case called Ex parte Queren, which was a case about 8 German saboteurs who came ashore during World War II to come blow up factories and commit other acts of sabotage. One of those German soldiers, and they were all rounded up, one of them turned the other ones in, the FBI got them all, but they took them over into military jurisdiction, and they were going to try them by military tribunal. One of them claimed to be an American citizen, and he had been an American citizen. He lived here. But the FDR administration, Franklin Roosevelt, argued that we don't care if he's an American citizen. We're going to try him by military tribunal anyway, and I'm not going to turn him over to any civilian court. That's what FDR said. Well, this is the same New Deal court that reviewed this case, Ex parte Queren. 1942, this is the same court that had given FDR everything else he had wanted, right, in the New Deal. It's also the same court that 2 years later in the Korematsu case would rule that it's constitutional to detain over 100,000 American citizens just because they were of Japanese descent. So this is the same court. Keep that in mind. So what did the court rule? Well, they said, well, if he'd have been charged with a crime that's normally tried by jury, then he would get a jury trial. But he's being charged with committing violations of the laws of war, and so what matters is not whether you're a U.S. citizen or not. What matters is what you're charged with. And if you're charged with violations of the laws of war, the court said, then the proper court for those charges is a military tribunal. Now, how many folks here believe that's accurate? Okay, let's look at the Constitution. That should always be our first stop, right? Article 3, Section 2 says the trial of all crimes, except in cases of impeachment, shall be by jury. And the next section, Section 3, Article 3, Section 3, says treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. That right there is the smoking gun for you to understand both what is supposed to be happening and for you to understand how much our Constitution is being subverted because it's not happening. What do you do with an American like Yasser Hamdi or Jose Padilla or that guy back in World War II who was making war against his own country, or aiding the enemy, what you do with them is you try them for the crime of treason. This is the only place in the Constitution where the elements of a crime, the definition of a crime, are laid out. Elsewhere, Congress has delegated like with piracy, they can define and punish violations of laws of international law or piracy. But here they've defined a crime. Treason shall consist only in levying war against the United States or adhering to their enemies, giving them aid and comfort. That's the definition. That is what Padilla and Hamdi were accused of. That's what Al-Awlaki was accused of, who Obama had killed with a predator drone strike, and his teenage son. Now you might say, well, they're all dirtbags. Al-Awlaki was a dirtbag, and Padilla's a dirtbag, and Hamdi's a dirtbag. Any American who goes over the enemy is no longer an American and deserves to be, taken off to a military brig. Well, that's not the founders' design. Because what's the legal difference between them and you? There is none. If you unleash the government, take off the chains of the Constitution because you want to get at dirtbags, then what's going to happen to you? That power will be used against you eventually. Right now, what does DHS consider the greatest threat currently, their big focus for counterterrorism? Yeah, is it Islamic terrorists? Is it radicalized Islamicists, either here or abroad? No, their biggest focus is like in the Mayak report, that came out, and that's the tip of the iceberg, is Ron Paul supporters or Constitution Party supporters or Tea Party people and veterans. In particular, veterans are listed as the grave potential threat. Now, why is that? How many of you are veterans? Who's ever served in the military? Are you a threat? But what are you a threat to? I agree, I'm a threat too. But guess what? We're not a threat. Are we a threat to the American people? Okay. We're a threat to their agenda, to the powers, to the agenda of the domestic enemies of the Constitution. We are a threat to their agenda, and that is true. So they are properly focusing on their future enemies who are going to fight them. But the reason why, and the only reason why we will ever have to fight, is because they have put themselves in the posture of being domestic enemies of our Constitution. And so people need to set aside any idea that all of this is being done only to get at Islamic terrorists, as though that would make it okay. It doesn't. If you think the government needs more power than the Constitution gives it, then by all means go sponsor an amendment. Go advocate for an amendment to the Constitution and see if you can get it passed. But until such time as it's amended, I will defend it. All of you who swore an oath to support and defend the Constitution, you have an oath, an obligation, and duty to defend all of it, whether you like it or not, whether you think it goes far enough or not. Now, the founders, in their wisdom, put that requirement of and treason clause doesn't just define the crime of treason. What's it say? No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act, or on confession in open court. Extra protections, because they knew the charge, the accusation of being a traitor is the worst thing you can accuse anybody of. The only thing that comes close nowadays is terrorist. Traitor is even worse than accusing someone of being a child molester. And usually what happens if someone's accused of being a child molester? People are like, oh, that dirtbag, I hope he fries, before he's even been tried. They've already convicted him inside their head. Same goes for someone accused of being part of Al-Qaeda. That's why you see all these talking heads on TV and politicians saying, oh, any American who goes over to Al-Qaeda doesn't deserve a jury trial. It's like, well, how do you know they're guilty yet? This is the dumbing down of America. It's a good example. Even in the worst accusation against an American, the founders didn't just demand a jury trial. They said, that's not even enough. You got to have two witnesses, not just one, not a secret witness, 2 witnesses to the same overt act. So if you had one witness against one action, another witness against that other action over there, that even wouldn't be enough. They wanted extra protection because they had seen the history of the Star Chamber in England, where someone was accused of being a traitor against the king, and then put in front of a panel of hand-picked pals of the king. That was their jury. It was the joke. They had seen that history. And they'd also lived through their own history, where you had denial of jury trial was done to them. What else does it say? Or confession in open court. And what is that designed to stop? Torture. Designed to stop coerced confessions. In England, they would torture you until you confessed in private, and they would use that confession against you and say, well, he confessed his crimes. And they would execute you, usually by having you drawn and quartered. And of course, since then, we've seen the same thing happen in the show trials in Stalinist Russia, right? How many of you guys remember that back from the 50s and the 40s? They put you up in a show, the same thing happened there. They torture them until they confessed, and they would use the confession to convict them. So the founders knew and understood how people would become restive and angry and want to circumvent due process and normal criminal law to get at bad guys during wartime. That's why that's there. It talks directly about what you do with an American accused of making war against his own country. They understood warfare. They understood emergencies. There's this bizarre notion nowadays that, well, the Constitution is for normal times. When there's a real emergency, well, you're going to set it aside. And we saw that during Katrina, right? Where you had, in the name of an emergency, you had the Second Amendment thrown in the trash can. And they had door-to-door confiscation of all the weapons. And the mayor got up on TV and the police chief got up on TV and said, we're going to take all the guns. No one's going to be allowed to have a weapon. And they did that. Was that constitutional? Wait a minute, it was an emergency. And I did an interview with Bill O'Reilly about that, and I couldn't believe Bill O'Reilly actually defended the gun confiscation in Katrina. And he's like, but it was a state of emergency. I said, I don't care what you call it, it's still not constitutional, it's still unconstitutional. You know, bad weather doesn't suspend the Second Amendment. When do you need to be armed? It's for emergencies. The militia of the several states is supposed to be able to do what? Repel invasions, suppress insurrections, execute the laws of the Union. And who's it supposed to be? That's you. So the Bill of Rights and the Constitution was written for emergencies, not for normal times, then you set it aside. That's what they're for. If you think that you have an insurrection or domestic enemies, internal enemies that are so dangerous that you have to do something extraordinary with them, what's the remedy for that? It's called habeas suspension. Congress has the authority for detention. Congress can suspend habeas corpus, which allows them to detain people without charge. I don't like it. If I was at the Constitutional Convention in 1787, I would have voted against that. I don't think it's necessary at all. But that's the constitutional detention provision. So you can detain someone once Congress suspends habeas corpus. And when can they do that? When in cases of insurrection or rebellion or invasion, the public safety requires it. But Congress has to do it. Has there been a habeas suspension? No, there's not. Even if there has been, even if there were one, would that then allow the government to apply the laws of war to Americans? No. Would it allow them to say they suspended habeas corpus and they could detain you without charges? Would that allow them to use military tribunal against you? No. The trial remedy is still the treason clause. A jury trial for treason is still the remedy. Now, and that was what was done with everyone accused of treason throughout American history up until the Civil War. The Whiskey Rebellion, Shays Rebellion. Aaron Burr, who was accused of raising an army against the United States, was tried for treason. But where was he tried for treason? In front of a jury of his peers in a civilian court. When John Brown attacked Harper's Ferry, same thing. No American was ever subjected to military tribunal, unless you're in the Army, until the Civil War, Lincoln was the very first president to open the door to martial law in America. And most folks know that he suspended habeas corpus in Maryland, right, on his own. But then what happened is Congress passed a habeas suspension statute. They kind of rubber stamped what he'd already done, but they passed a statute that said that we suspend habeas corpus, and how it would work is the government had 20 days. They could detain you without charges for 20 days, but that's it. At the end of the 20 days, according to the habeas suspension statute, at the end of the 20 days, they had to either indict you by grand jury or release. That was the rule. Lincoln ignored that. He held people way beyond the habeas suspension statute for years, including a congressman, northern congressman that was critical of the war effort, anybody who dared criticize how they were running the war or who were calling for peace terms or anything like that was rounded up. Editors, newspaper editors, reporters were rounded up and put in jail. He had over 15,000 northern civilians detained, and his reasoning was they are military enemies, is what he said. They weren't Southerners who were part of a breakaway nation. When the South broke away from the North, they had their own president, their own vice president, their own Congress, their own money, raised armies and navies. They became a separate nation. And they treated each other, the North and the South, during the Civil War, treated each other like separate nations. They exchanged prisoners, they had truces and ceasefires. They did all these things as if they were, foreign nations. They held each other as POWs. If you were a Southerner in a uniform and you were captured, could they just shoot you and kill you as a murderer or charge you with murder? No. You had the protections of the laws of war that would hold you as a POW. Same for the Northerners. If you were accused of violating the laws of war, such as not wearing a uniform and sneaking up to the North and to do some sabotage, they would hang you as a spy or as a saboteur because you weren't wearing a uniform. That's just the way the laws of war have always gone. But Lincoln did not just apply the laws of war to the South that are broken away. He also applied it to Northern citizens, people who were not part of the South. They were in the North, civilians. And 15,000 were detained, and about 5,000 of them were tried by military tribunal. And there was one man named Milligan, and some of those were put to death. One man named Milligan, he was sentenced to die. He was a citizen of Indiana, accused of plotting to set Southern prisoners free who were in a prisoner camp up there, plotting to raid an armory, and also plotting to kill the governor or kidnap the governor. And so he was accused of violating the laws of war and tried by military tribunal and sentenced to be executed. He appealed to the Supreme Court. Lucky for him, the war had already ended. Lincoln had been assassinated, and the court heard his case in 1866. It's called Ex parte Milligan. And I want to read you a couple pieces from that. In that court case, here was the argument of the U.S. government. And let me know if this sounds familiar to you. Milligan said, hey, I have all the rights to jury trial under the Bill of Rights. And here was the government lawyer's response. The Bill of Rights, these in truth are all peace provisions of the Constitution, and like all other conventional and legislative laws and enactments are silent amidst arms, and when the safety of the people becomes the supreme law. By the Constitution, as originally adopted, no limitations were put upon the war-making and war-conducting powers of Congress and the President. Does that sound familiar? That's the claim nowadays, since 9/11, that, hey, this is warfare, and there's no limitations in the Constitution on the war-making powers of the presidency. That was the argument. The fallback was, finally, if the military tribunal has no jurisdiction, the petitioner may be held as a prisoner of war, aiding with arms the enemies of the United States, and held under the authority of the United States until the war terminates. So they argued that, hey, even if the court rules that the military tribunal can't, prosecute him and convict him and have him executed, we can still hold him as a POW. This is exactly the same arguments we're hearing today. Here was the court's response in Ex parte Milligan. Even these provisions the Bill of Rights, expressed in such plain English words that it would seem the ingenuity of man could not evade them, are now, after the lapse of more than 70 years, sought to be avoided. Those great and good men, those who wrote the Constitution, foresaw that troublous times would arise when rulers and people would become restive under restraint and seek by sharp and decisive measures to accomplish ends deemed just and proper, that the principles of constitutional liberty would be in peril unless established by irreparable law. The history of the world had taught them that what was done in the past might be attempted in the future. And they say, the Constitution of the United States is a law for rulers and people, equally in war and peace, and covers with the shield of its protection all classes at all times and under all circumstances. No doctrine involving more pernicious consequences was ever invented by the wit of man that any of its provisions could be suspended during any of the great exigencies of government, which means during wartime. The court pointed out that he was a northern civilian, he's an American citizen. They said, we don't care what he's charged with. The military tribunal has no jurisdiction. And neither do the laws of war. What counts is who he is, not what he's charged with. Well, that was the court putting the martial law genie, the laws of war genie, back in the bottle. And that stayed there all the way through every other war we had until World War II, when FDR grabbed that bottle back up and popped the top off. And then in the New Deal court, the same court that said it's okay to intern Japanese Americans because of their race, went along with it and said, oh, well, no, ex parte Milligan, they misconstrued Milligan. And if you folks want to, you can go on our website, oathkeepers.org, and I've got a really long paper I wrote in Yale Law School when I was a student there in 2004 that breaks down exactly how they got around their own prior precedent and how they got around the constitutional provisions by arguing, like I said earlier, that, well, what counts is what you're charged with. So long as they charge you the laws of war, then there'll be a military tribunal. And that's the 1942 case, ex parte Quirin, that laid around like a loaded gun. Almost forgotten since then. So Lincoln did it. It was never done again until FDR. He did it to one citizen. That was it, other than Japanese American internment. But one citizen was tried by tribunal, and after that, not until after 2001 did they reach back and resurrect that old 1942 World War II case and say, oh yeah, look at that. We can go ahead and use military jurisdiction even on American citizens. Now, why did the founders put this restriction in the Constitution? Why do they mandate jury trial? Well, first of all, it was an ancient right of jury trial, right? And they experienced themselves a violation of jury trial. If you go look at the Declaration of Independence, it lists there the charges against the king. Among them were these: he has affected to render the military independent of and superior to the civil power. And that was the martial law in Boston under General Gage. But it was also the use of courts of admiralty back then in order to get at a notorious smuggler like John Hancock. If they were to charge him with a normal crime in front of a jury of his peers, what would have happened with the jury in Boston? He'd have been acquitted. The jury would have used its full power to acquit, even in the face of an unjust law. They would have acquitted him. And so the Crown began to use courts of admiralty instead for those accused of smuggling. And they expanded the jurisdiction of the admiralty courts, not just to what was going on in the seas, but into the ports and into the towns, into the cities. But a big part of it is also what they're talking about was martial law under Gage. The NDAA of 2012, which just builds on what's already been done and codifies what's already been claimed, does the exact same thing. It renders the military independent of and superior to the civil power. The military, a stroke of a pen, Panetta and the DOD, or any of his flunkies, or anybody else the president wants to designate, can just point a finger at any one of you or anybody else in America and say, you are no longer in the civilian system, you are now in the military system. You're now an enemy in warfare. Other charge against the king. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. What is more foreign to our Constitution than the international laws of war? And Obama's done the same thing now. He's joined with others, Congress, to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws. Where in the Constitution does it say Congress has the authority and the power to declare war on the American people? Is it in there? No authorization to declare war on the American people. They've got no jurisdiction. Warfare, the laws of war, have no jurisdiction over us under our Constitution. Another charge, for depriving us in many cases of the benefit of trial by jury. And this is the big one. How'd that happen? It was done by statute. Parliament passed statutes that denied jury trial to Americans accused of being smugglers or anything else they wanted to do. And they had another one, another statute for transporting us beyond the seas to be tried for pretended offenses. That was also a statute passed by Parliament. Allowed them to say, okay, an American accused of treason will not be tried in front of a jury of his own peers in the colonies. He'll be taken across the seas to England to be tried in front of an English jury. There was also a direct violation of the ancient right of jury trial. Who's supposed to be tried by? Your peers. Where? Where you live. Under the NDAA, it's the exact same thing. You're being stripped of your right to jury trial. You can just be grabbed up by the military in the middle of the night without any grand jury indictment, no jury trial, no finding of guilt by a jury of your peers, and is taken off to Gitmo or any other military brig for the duration of the conflict, for the duration of the war on terror. And if they want to, they could also accuse you of violating the laws of war. Now, what are violations of the laws of war? Anybody know? Remember back we talked about a minute ago about not wearing a uniform. That's one of them. If you're accused, once you're not just accused, once the president designates you, like say he designates Ed as an unlawful belligerent in the war on terror, Ed's only shelter would be, he'll hold him as a POW if he's complying with the laws of war. But if Ed's not in compliance, then he'll try him for that violation of laws of war and execute him. And all kinds of spies throughout history who were wearing civilian clothes, not wearing a uniform, are strung up, right? So what's a violation of the laws of war? Not wearing a uniform, or not having an insignia recognizable at a distance, like an armband with a big emblem on it. So, I'm not wearing a uniform right now. Hardly anybody else in here is wearing a uniform. We're all in violation of the laws of war, once so designated. Another one is not bearing arms openly. So all you guys out there with concealed carry permits who are carrying concealed, you're in violation of laws of war. And that sounds absurd, but if they're going to turn you into an enemy in warfare just by saying you are one, then they can say, well, you're not complying with the laws of war. Another one is being in a command structure, recognizable command structure with authority over you. If you're not in a recognizable command structure, once again, you're in violation of the laws of war. This is the Alice in Wonderland absurdity that they're applying to us right now. So, here's where we are. We are in a direct parallel right now to what the forefathers of our country, what the founding generation was facing in a lead up to the revolution. A long train of abuses. What do they say about that? Long train of abuses. Here, I'll find it in a second here. A long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism. That's what we're facing now, a long train of abuses that's evidencing a design to reduce us under absolute despotism. What can be done to an Iraq goat herder right now in Iraq who the U.S. military suspects of being part of the insurgency? An insurgent. Kill him. That's right. That's the other thing that can be done to an enemy in warfare. You don't just detain them, you can also just kill them, right? With a Predator drone strike or whatever else. So that's the logical conclusion to all of this. And I predicted this back in 2004 when I wrote my research at Yale. I said, hey, if you can detain somebody under the laws of war and apply the laws of war to them, you can also just kill them. And that is what has begun to happen. There are not just Predator drone strikes against people in Pakistan or Afghanistan or wherever else against non-U.S. citizens. There's also been three Predator drone attacks against U.S. citizens. Obama has begun to order the execution, the assassination of U.S. citizens. And he says, this came out in a court case, a challenge by al-Awlaki's family. He disclosed the fact that he has a list of other Americans he is going to have assassinated by the military. But it's a secret list. He will not show it to you. It's a state secret. So there's a secret list out there somewhere in the White House with American citizens' names on it. It's like the Hunger Games. It's like a lottery. Who knows whose name's on there? We don't know. It's a secret list. It could be my name on there for all I know. He is claiming the authority and the power, the same authority and power that Hitler had, or Stalin, or Mussolini, or Mao, or Pol Pot, which is the absolute power of life and death over everybody in the country. He can just point at you and say, have that man killed. So even if you think you'll be okay in a military tribunal, even if you think you'll be able to prove they made a mistake and I'll be able to get out of Gitmo, you might not get to Gitmo. You might just get greased. I know it sounds like, oh, it's only been done to a couple of Americans. What are you worried about? Well, the founders didn't rebel. They didn't wait for the full effects of the tyranny claimed, of the powers claimed by the king and parliament, did they? They didn't wait until thousands of Americans had been taken across the seas, tried for treason in a kangaroo court and executed. They didn't wait for thousands to be rounded up and tried by courts of admiralty instead of a court of a jury of their peers. They rebelled against the principle. And one of the things that the Crown claimed was the Parliament was the power to regulate them in all cases whatsoever, the Declaratory Act. That's a counterpart to Pelosi's statement, in modern America. Then are you serious? I can do whatever I want. So we're facing the same exact parallel to what they faced. If we don't stop this, right now we're pretty much on a short track to another revolution. It's either that or you become like Nazi Germany. And you think I'm exaggerating? Go talk to someone who lived in Nazi Germany or Stalinist Russia. I have. I interviewed a lady in Kansas who grew up as a young girl in Germany, and she said, this is exactly what happened there. And she pulled out a copy of the Reichstag fire decree, which was passed right after the German parliament. The Reichstag was burned to the ground. Turns out later on when Nazis set the fire. But the point is that after that attack on their parliament, they passed the Reichstag fire decree, which triggered provisions in the German Constitution, the Weimar Constitution, Article 58 of it, had an emergency escape clause that says that, in certain emergencies, the president can declare an emergency and suspend certain rights of the people, like due process. So they triggered that in a Reichstag fire decree, and the president declared the emergency, and they suspended large parts of their own constitution. Do we have a like provision in our constitution that allows me to be suspended? No. That's what the Supreme Court was saying in Ex parte Milligan. Nothing allows it to be set aside and suspended. The closest thing to it is habeas suspension, which has not been done. Now, then they came, after the Reichstag fire decree came the Enabling Act. That's the one that said, well, the chancellor, that was Hitler, he needs the flexibility to do executive orders and rule through executive orders and all these things without having to go to the parliament whenever he needs something done. And so we're going to free his hands and let him have the discretion to do what he thinks needs to be done. That was it. After that, Hitler just did whatever he wanted to do. Sound familiar too? What did Panetta just tell the U.S. Senate when it comes to war powers? Well, we're going to go get authorization from the international body, the United Nations, or NATO, and we may let you know what we're doing, or we may not. We'll just go do it on our own. And he wasn't the first one to claim that. When they went to Libya, before they went into Libya, what they call that? They didn't call it war. What did they call it? A kinetic of action, something like that. Before they went to Libya, where did Obama go for authority? Did he go to Congress? He went to the United Nations. He went to what he is willing to recognize as a body that has any say in what he does. He sees himself as the president of the world, so he went to the World Congress, the United Nations. Congress has become like the German Reichstag, like the German parliament. It's become a farce, a joke. The presidents, and I mean all of them in modern history, Reagan, Bush 1, Bush 2, Clinton, Obama, all of them claim that they don't have to get congressional authorization to do any of these things, that they have an independent power as commander-in-chief, and not just to act against foreigners, but to also act against you. So we really have an imperial presidency now. And what's happened is now we are in a direct parallel to what happened in 1798. And this is where I'm going to talk about solutions now. In 1798, you had the Alien Sedition Acts passed. How many folks know what that is? That was, and this is also during a war. This is the undeclared quasi-war with France, where you had the French Revolution and you had a lot of the people in the Adams administration who were, kind of like closet monarchists. They're really in love with Britain and the monarchy. They saw the French Revolution as a grave threat to world stability. And they thought the Jeffersonians were American versions of those radical Jacobin Frenchmen. And they thought they were a subversive element. And so they saw them as internal enemies. And so they wanted to crack down on these internal enemies. They passed the Alien Sedition Acts, which allowed them to deport any dirty Frenchman. But then they also said, any American who's criticizing the government is committing subversion, and sedition, and so we want to be able to lock them up. And even though they had just had the Bill of Rights passed, right? The ink was hardly dry on the Bill of Rights on the First Amendment, and they passed this law which authorized arrest and imprisonment of newspaper editors, reporters, anybody who spoke out and criticized the government, and they did it. And so you had Congress voting for an unconstitutional law. You had the president, John Adams, signing an unconstitutional law. And what do you think what would happen if they had gone to the federal courts back then? Who was in the federal courts? More Federalists. The Federalist Party controlled all three branches of the national government. There was no redress, no remedy by going hat in hand to the federal courts, part of the same machine, and saying, please find that unconstitutional. In fact, the Chief Justice of the Supreme Court, Justice Chase at the time, was riding circuit and doing trials, and he was directing juries that they must convict under the Alien Sedition Acts, telling them they had to, in direct violation of the power of the jury to acquit. He was saying, you have to. So, no chance of the federal courts fixing this. So when Jefferson and Madison saw what was happening, saw this gross violation of the First Amendment, what did they do? Did they file a court case? No. They went to the state legislatures. They wrote the Kentucky and Virginia resolutions saying the state legislature, and this is a parallel to what she was saying earlier, they said they have the right and the duty to declare this unconstitutional law to be null and void from inception, to be of no force and effect, and they had a duty to interpose themselves and protect the people of their state against an unconstitutional, invalid federal law. They went to the states. The states were the bulwark of resistance, they thought, to an unconstitutional law. So here you have James Madison, who's considered the father of the Constitution, and Thomas Jefferson, the man who penned the Declaration of Independence, both saying, this is what happens. The Constitution is not just whatever the court says it is. And the legislature, all of us who swore an oath, everyone who swore an oath to support and defend the Constitution, has an obligation, a duty to stand up and defend it against the other branches in government when they step out of the bounds. That's the whole point of a dual sovereignty system, as was clarified again in the 10th Amendment. Speaking of the Bill of Rights and the 10th Amendment, 9th Amendment, what was the point of the Bill of Rights? What? No. That's not it. I'll read you the preamble, which tells you the point of what the purpose was. The conventions of a number of the states, having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. The point of the Bill of Rights is to prevent misconstruction or abuse of the powers granted the new government in the Constitution. Now, even at Yale Law School, we were told that the powers of the federal government are few and defined. You know, they're enumerated in the Constitution, they're few and defined. But through the Commerce Clause, we all know that Congress has claimed now the authority to make a law about absolutely anything. I mean, you name it, anything. Pick something that you think Congress cannot regulate. I challenge you. They can. A wheat farmer growing his own wheat for his own consumption in 1942 in the Wickard case was ruled to be within reach of Congress, even though he wasn't growing it for sale, even though he wasn't selling it to anybody, wasn't going across state lines. They said it has an effect on commerce because he's not buying wheat in the wheat market. So we can regulate that. And since then, they had an open door. The only time since then that the Supreme Court, has even tried to trim that back was in the Lopez case, a case about the Gun-Free School Zone Act. They said, what does that have, why do you have to have a regulation against guns being near schools? What does that have to do with commerce? And the U.S. government back then, this is the 90s, said, well, you know, having guns around the school affects the learning environment because you're afraid, and that will affect your ability to get a job later on when you graduate from high school, and so that means it affects commerce. And the court, Thomas writing for the majority, said, that's ridiculous. It's got a very, you know, like 18-point removes away relationship to commerce. Has to be some limitation. They ruled that didn't have a close enough relationship to commerce. It's not even commerce at all, right? The gun possession. But at least they trimmed it back a little bit. Unfortunately, then came the Race decision. And the Race decision, Gonzalez versus Race during the Bush administration, was of a lady in California. California had legalized medical marijuana. And so under state law, she was legal when she grew a marijuana plant in her own backyard for her own consumption. Like the Wickard farmer, like the wheat farmer in Wickard, not for sale, just for her own use, not crossing state lines. But because it was, and under Lopez, she was squared away. But because it was a drug case, Scalia, I guess he doesn't like drugs, decided to go along with the liberals on the court who want the absolute power to make all laws in all cases whatsoever, just like Parliament did. Scalia went along with he reversed himself. In Lopez, he went along with Thomas. In the Race case, he went along with the liberals on the court and said, oh no, Congress can regulate this. And they said, well, what is she doing that has an effect on, what's the market she has an effect on? What are you talking about? And they said, oh, it's the illegal market in marijuana. She's affecting the illegal market because she's growing her own plant and not buying it from some drug dealer. It's an illegal market. It's just absurd. So that's where we are now. That's where we're back in this. Congress can make any law it wants to about anything. So that's been going on since friggin' the New Deal in 1940s. And we have seen what's happened, all of it, Obamacare, you name it. All these gun laws, they're totally unconstitutional. All of this nonsense has been done under that power. But now we see they've always had that, been building that up for decades. But now the other great big power grab is the military being brought home. Pay attention to this now. This is so much more dangerous. Not only can they make a rule about anything you do, they could outlaw homeschooling. They could mandate that your children have to, who knows, just all kinds of stuff they could mandate you have to do in your home, all in the name of regulating commerce because it affects commerce. Now, add to that, building up all their power over here, but over here ripping down your defenses, tearing down the Bill of Rights, tearing down any limitations on their power. Jury trial? Gone. Grand jury indictment? Gone. Right to confront your accusers? Gone. The right to be free from self-incrimination? Gone. They will send you to friggin' Egypt, have them torture you, you'll confess under torture, they'll bring you back to the military tribunal and get Gitmo, and they'll use that tortured confession to convict you. And once you're in this system, it's not just, well, so long as I'm not actually part of Al-Qaeda, I'll be okay. How do they know you're part of Al-Qaeda? The president says so. And once you're so designated, he just merely points his finger and you're designated. After that, what's your recourse? Well, the Supreme Court in the Hamdi case said, well, the power of the president is not unlimited. He can't just do whatever he wants. You have a right to challenge your designation. But they also said, however, a military tribunal may satisfy that requirement. It may be enough, so long as it's an impartial, review by an impartial decision maker to determine whether or not the status is legitimate. What's the burden of proof going to be? Beyond a reasonable doubt? No. Probably preponderance of the evidence. And who's going to be deciding? A jury? No. A military judge. There'll be a military judge who determines your status. Whether it's when you challenge your status, you're in Gitmo, you're like, you got the wrong guy, I'm not part of Al-Qaeda. And they're like, okay, tell it to the military judge. How do you think it'll turn out? What do you think? You want a good indicator how it'll turn out? Look at the recent hearing at Camp Pendleton for the Marine Sergeant Gary Stein, who had the Armed Forces Tea Party page, and the Marine Corps just drummed him out of the Marine Corps with an other than honorable discharge. I was there in person as part of his defense team. It was a fiasco. It was a kangaroo court. It was a joke. Predetermined results. A hand-picked panel of officers and senior enlisted who took 40 minutes at the end of all of our evidence, denied us to even present witnesses. We had a retired brigadier general who was a JAG officer throughout his whole career there to testify as an expert on the law and the military regulations and where the lines are of free speech in the military. Wouldn't let him testify. I had a retired major who's in Marine Corps combat infantry leader in Oathkeepers there to testify about the effect of good order and discipline. I had Marine recruiters who were there to testify about the effect on recruitment. If they go ahead and do this to this guy, none of them were allowed to testify. He was not allowed to present witnesses on his own behalf. So instead, we presented written testimony from these same witnesses. Some of them written right that same day, in a big panic. Write something up from the brigadier general. Submitted it to the panel. They had a stack like that of things we gave them. Law review articles, court cases, written statements by witnesses, etc. They took 40 minutes to make their decision at the end of the presentation of evidence. Do you think they read all that? No. That is the kind of system they will now say, and it'll be even worse. He's a Marine only accused of saying a few things against President Obama, critical of the president. Get a little hot under the collar in an online chat with a couple other Marines, said a couple things he probably shouldn't have said. But that's nowhere near like being accused of being a terrorist. So imagine what you'll get in front of a friggin' military hand-picked military tribunal, hand-picked by President Obama. So that's where we are. So what do we do about it? Well, I think the model shown by Jefferson and Madison shows us the path. It's the middle ground, as they said, and as Thomas Woods always reemphasizes when it comes to nullification. If you haven't read his book, Nullification, I encourage you to read it. It's the middle ground is for the states to stand up. And what they did two things at the same time. On the one side, they went to the states and said, you have a duty to protect the people against this unconstitutional law, an absolute duty. And on the other side, they kicked the bums out. It was called the Revolution of 1800 later. They swept the Federalists out of office. Because at that time, at least, a majority of the American population understood their rights, understood their own recent history, that they had just fought a revolution to stop that kind of tyranny. And they could see clearly that this was a violation of the Constitution. And what did they do? They kicked the bums out. It didn't matter. The party didn't matter. What mattered was being an American. If we can do the same thing now, we might be able to avoid having to fight. But I don't know if we can do it. Americans are so slavishly devoted to their party. They're willing to swallow. Romney said he would have signed the NDAA. The last guy the Republican Party gave us was McCain. Who do you think wrote the detention provision in 1021, Section 1021 of the NDAA? It was John McCain. They keep giving you guys oath breakers, and they keep telling you, you must vote for our oath breaker. Because if you don't, then that other oath breaker over there is going to get in office. Lesser of two evils. And Americans keep falling for it. And so long as Americans continue to vote the lesser of two evils rather than voting as Americans, so long as they continue to vote as Republicans first or Democrats first and do what the party tells them, we will not be able to have a political check on this abuse. And the NDAA was passed with the overwhelming majority by both the House and the Senate. You had only 7 senators voting against it in the Senate. What do you think the odds are of a political solution? Slim and none in the short term. I do believe, given enough time, we would win eventually, because the internet, homeschooling, all of these things help to counteract the propaganda, the intentional dumbing down of Americans. It gets the truth out there. And one drop of truth is an antidote to a whole bucket of bull. And that's true. But the problem is they know that too. That's why they want to shut the internet down. And all this emergency law stuff, all this idea of the laws of war and martial law, all of that we are in danger of having that triggered. All it will take is the right pretext or the right political cover. Because is there a constitutional barrier anymore? Not according to the Supreme Court. Just like in Jefferson and Madison's day, you had all 3 branches of the federal government in agreement on a violation of the Constitution. Today, it's the same way. The executive branch of the Republican Party and the Democrats, both of them, every major candidate out there except Ron Paul, in fact, all say it's okay to do this to American citizens. Bush did it. Obama has gone one step further. We're going to kill Americans. The courts have agreed to it, and now Congress has signed on and said, yes, we agree with everything you have done in the name of fighting the war on terrorism under the AUMF of 2001. That's what the National Defense Authorization Act does. Refers back to the 2001 AUMF and says we affirm that in that 2001 authorization for use of military force, we did authorize the application of military jurisdiction, the laws of war, to any person, it says. Not any person who's not a citizen, not any person except citizens, any person who the president determines meets these criteria. And we authorize, and that did include the authorization of military detention, military trial, or rendering them over to any foreign nation or any foreign entity. Any foreign entity. And who could that be? United Nations? NATO? The drug cartels? Who knows? Anybody they want to. Al-Qaeda? That'd be ironic. So what do we do about this now? At this point, according to Congress, the only real check you have is in the political process. The only real check you have is to vote somebody else in that will not authorize that to be done to you. So they've taken away the shield of the Constitution and said now it's just a matter of mere politics, whatever Congress wants to do. As though we were like in England, where they can just do what they want. There's no constitution, no written constitution higher than the will of Parliament in England. So that's where we are now. But the other remedy that they don't want you to talk about is state nullification. And when I talk about nullification, and I was just at a conference in LA with the 10th Amendment Center about NDAA, when we talk about nullification, we're talking about as individuals, and that's why I talk to the military. They have an individual duty and responsibility to nullify by saying no. They will not enforce an unconstitutional law. Every police officer out there has the same duty. Every sheriff out there. And so that's why I've helped to co-author resolutions. How much more time do I have? Okay, I'm out of time. That's why we co-author resolutions against the NDAA. They can be signed by sheriffs, by county commissioners, by towns, and by states. We have to nullify at every level from individuals on up all the way to the top in our states. If we don't do that, if the states don't nullify, if the sheriffs of the country don't step in, if they don't defend the people against this, what is going to happen? Do you think we'll just slide into Nazi Germany, our own little weird version of it? What do you think? No, no. And why I say no is that the veterans of this country will not let that happen. If we are forced to choose between 1935 Germany and 1775 America, we will choose 1775, and we will fight. We will have no choice, just as they had no choice. They're putting us on a short path to having to make that decision, and I've already made my decision a long time ago. I talk to veterans across the country, and the last thing I'll say is they tell me, they say, you know what, and I've heard this from multiple veterans that don't even know each other. They say the first time I see some veteran detained under the NDAA, it's on. That's what they say. I'm not going to wait for them to come to my door. It's on. And what do you mean by that? That means they're going to go get the bad guys.